Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So last night, after I worked all day, I sat down to enjoy this long-running comedy show that's been playing on YouTube called The Darrell Brooks Trial. And as usual, I got plenty of laughs out of it in sort of a odd way. So I want to talk about what Darrell Brooks can argue when he does his closing argument at the end of the day today. Stay tuned. So, one of the funnier moments in the trial, for those of us who were attorneys, came when Mr. Brooks announced to the judge, well, I'll just let you watch a little bit of the clip.
You are. Then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to nullify laws paid over. You are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir.
So, Mr. Brooks seems to think he can argue jury nullification. Now, within certain limits, you can come close to arguing jury nullification. You can say, you're the jury, you have the power, power to believe or disbelieve. But what you can't do is you can't just say, because I'm a poor guy who got caught up in the system and they've treated me so unfairly in this trial, you just have to let me go. Because that is not going to happen. And the judge will issue an instruction to the jury not to let that happen. And that's just the way the law works. Somebody asked me the other day, what would happen to me as a lawyer if I acted the way that Darrell Brooks has acted in this trial? Well, about the first time I rolled my eyes at the judge, I would get a very stern rebuke and be told not to do it again. The second time, I'd be pulling out my checkbook and writing a check to the registry of the court for somewhere between $100 and $500. And on future episodes, if I were to roll my eyes, I'm pretty sure I'd wind up in contempt and get to spend the night in the county jail. Because judges do not put up with the kind of hijinks from lawyers that this judge has very patiently weathered from Mr. Brooks. You don't get to do that. You don't get to make objection after objection that's frivolous. And in fact, your opposing counsel will say, Judge, he's making frivolous objections here. If he does that, the judge is going to tell you not to do it. And if you violate that order, we're back in the same ballpark, contempt. So the reason she's not holding him in contempt is because it might appear to show bias, and she's trying very hard not to damage his appearance in front of the jury. And of course, I don't know whether he's too clueless to realize what he looks like in front of the jury, or he is intending to look like a complete jackwagon in front of the jury. I don't know. But either way, that's sort of where we are. So getting back to argument, what can you argue in closing statement? Well, first of all, you are limited to the evidence that was presented under oath in court. So what does that mean? It means that he cannot get up in closing argument and say, I didn't do this thing, because that has the character of testimony. And he didn't testify. Why didn't he testify? It wasn't because he didn't have a right. He certainly had a right. Somebody told him, hey, if you get up and you testify, you're going to be cross-examined on your criminal history. And what's coming into evidence? The child sexual offender, the fact that he impregnated a young lady in Nevada. That will come into evidence. And unfortunately for him, that was the reason why he couldn't testify and stand up and give some kind of explanation for what happened on that particular day. But he was at least smart enough to recognize that he didn't want to do that, because he would have been cross-examined. And irrespective of his complaint that, no, I didn't do that, and that's a lie, the fact of the matter is, you can look up on YouTube somebody has the receipts for the conviction and the sex offender registry. I don't deal in that. I don't put up receipts like that just because, frankly, if you're interested, you can go find them yourself. But I did see that, and he is indeed a convicted and registered sexual offender in the state of Wisconsin. So that's why he didn't testify, and because he didn't testify, he can't affirmatively state anything that is not evidence in the record as evidence. And when you stand up and say, I didn't do it, that's the same thing. The judge will rebuke him, and if he continues, she'll shut his microphone off until he can behave. Now, everybody gets 1 hour. What will happen is the prosecution will take 45 minutes. It'll be his turn. He'll get an hour or whatever portion of an hour he is allotted. And then the prosecution will probably get 15 minutes at the end to close it up. Because the reason the prosecution goes first and last is because they have the burden of proof. So what could Darrell Brooks argue that might help him here? Because there are some things you can argue that can help you, even if you can't argue jury nullification. As I mentioned earlier, you can say you've got the power. You've got the power to believe or disbelieve. You can believe what the state has said, or you can disbelieve what the state has said. Now, of course, what will happen is on rebuttal, the state will come back and say, yeah, everybody is lying except Darrell. You know, all the witnesses, all the cops, all the people who got run over, all the moms who came up and cried on the stand, every last one of them was lying. I'm sure that's a rational explanation. So I suspect he probably won't do that. But that's one thing you can do. You can get up and say, well, the state hasn't made its case, or the state hasn't proved an essential element of the case. For example, premeditation. You can raise those claims, but you can't raise evidence that wasn't admitted in court or that was purposefully excluded by the judge. So the way you get around some of that is to ask rhetorical questions. I had a good example of this in a trial that I witnessed several years ago. A young man was accused of inappropriate sexual contact with a minor. He was a school teacher, and he was accused of this. And as a result, when the police came and knocked on his door with a search warrant, they took his sheets, they took his blankets, they cut them up, and they sent them away for DNA. And of course, because the young lady had never been inside the house, something that was revealed later in trial, because she had the outline and the layout of the house all wrong, because of that, here's the thing. You get to ask questions of the state's witnesses. So during the state's presentation, the defense counsel said, you cut up these sheets. Yes, we did. You sent them for DNA. Yes, you did. And he stopped. He didn't ask any more. And the reason he didn't ask any more is because he knew they didn't find anything. So the state had an opportunity to come back and say, well, yeah, we sent them and we got hits on his DNA, but no one else's. They could have cleaned that record up, but instead they left it alone. And at trial, instead of telling the jury they never found any DNA, which sounds defensive, right? He worked on a psychological principle that works quite frequently in trials, and that is people believe what they come to of their own volition much better than they believe information that is, or conclusions that are handed to them. If you tell them they didn't present any DNA evidence, they didn't find any DNA, that has less of an impact of standing up in front of the jury and saying, do you remember when the detective testified about the DNA evidence, how they cut these sheets up and they cut these blankets up and they sent them to the lab for DNA? Do you wonder why they never mentioned the DNA? Do you wonder why they never said anything at all about DNA? Maybe you should think about that in reaching your verdict. You can ask those kinds of rhetorical questions. There is an art to arguing in front of a jury. And the art is basically, how do you call into question the state's case? So there is an art to closing argument. But closing argument actually begins well before the case ever starts with the development of a theme. Let's take, for example, the Casey Anthony trial. The Casey Anthony trial there, the very intelligent lawyer, Mr. Baez, I believe his name was, he developed a theme at the beginning, which was the state can prove a lot, but they can't prove murder. And that was basically what he did the entire trial. Yeah, the state proved that she was a liar. They didn't prove that she was a murderer. So the only thing she did suffer was a conviction for lying to the police. That's a good way to argue a case where you do have evidence that points to you, but also some that points away from you. So you emphasize the evidence that points away from you, and you attack the evidence that points towards you. And as a result, that's how you secure your release on charges that are somewhat unsupported by the evidence. Well, you have to understand that you have to have a theme going into the trial so that you can wrap that theme up at the end of the trial. So that's how you would conduct the oral argument, or the final argument in this case, if you wanted to do it according to the rules. I know for sure that Darrell Brooks is not going to follow the rules. He made some reference yesterday to he's just not going to do closing argument today. Well, that's not going to work either. The court gets to set the trial schedule, and if he doesn't like it, that's just going to be too bad. So I don't usually watch this trial live, mostly because it's just almost unbearable to watch this guy struggle through things and keep butting his head up against the brick wall. Yesterday, he built a box fort to hide himself because the judge muted him. Really? Do you think that was effective at all? Do you think that bothered the judge? I think, frankly, she was kind of glad not to see his face. So tonight we should get a recap of the trial, and the case will go to the jury. Now, how long do I think the jury will be out? They have 107 pages of jury instructions, and they're going to have to go through all 107 pages of those jury instructions in the jury room. And then they're going to have to take a vote on each of the counts. You know, murder in the first degree for count 1, murder in the first degree for count 2, murder in the first degree for count 3. And they'll have to go through all of those. And they'll have to go through the vehicular assault issues. Then they'll have to go through the bail jumping count. I thought that was really funny. Perhaps tomorrow I will do a video explaining double jeopardy and why this is not double jeopardy. So it's a very interesting case. It'll be a very interesting jury verdict. I suspect the jury will be out a minimum of 8 hours, just because they want to show that they did their job and they did it fairly. And I think that's certainly consistent with the oath and the obligations that jurors take. So if you have any questions, please leave them in the comments down below, and I would appreciate it if you would like, share, subscribe. You know all the things to do. It's great having you on the channel. Thank you so much for watching, and I will catch you after the trial. We'll talk about it tomorrow.